This is a very general overview. My area of practice is civil litigation. Most of the stuff you're going to be looking for is going to be in probate and county recorder records and things. But the purpose of today is so that you can kind of get an understanding of some of the more archaic words that you're going to run across while you're doing your research. So we can go ahead and get started. Allison already kind of ran through my background. She sounded a little proud about it. I'm not sure why, but so this is just a general overview of who I am. What I mainly do is, as a history major in undergrad, I do research and writing, appellate work, things like that, motion practice. So doing the research is something that's second nature for me, which of course plays into what you all do as well. First things first, as we know with any sort of genealogy record, it matters where you're looking as much as what you're looking for. So I'm going to use the example of Indiana, but every state has gone through, and frankly every country with their own legal system has gone through numerous names of different courts. You know, we see General Quarter Session of the Peace for the early territory days of Indiana. We have a Circuit Court of the General Court. We have a Court of Common Pleas, which is actually a term that's still used in states like Ohio, and that's continues to change as far as which counties use them, or even as time progresses here. So Circuit Court is a very common one, both in Indiana and in other states. Then of course you still have Court of Common Pleas. Superior courts, which were added, and I'll get into that a little bit. Superior courts are on the same level basically as a circuit court, but they are added on depending, like in the state of Indiana, you have superior courts added to circuit courts as counties grow. So the larger counties have more and more superior courts that get added on. Marion County, which is where Indianapolis is located, has I think 16, maybe more by now, superior courts in addition to the main circuit court. But so it's good, you need to check and see, okay, you're not just looking in Indiana court records or your state court records. You need to figure out, according to the timeline, even what court the record might be in. Now, here's something that's important to note when you're talking about timelines as well. So if you see on here, there is a Court of Common Pleas for Knox County, you know, in 1790 started. Well, so you think, well, I don't need to look in Knox County for my records. Knox is just one county in Indiana. Here's the problem with that. As of 1816, Knox County was almost the entire state. So when you're looking for records, you need to recognize not only where, you know, the specific name of the county is, or record that you're looking for, but also recognize that some of these territories and the counties have changed in their geographical presence significantly. So the records you're looking for, even though it says Knox County, could actually be your records even from down in, well, Allen County or anywhere. With what is now Allen. So we're going to run through now so you understand which different courts. This is the modern Indiana court structure. It looks kind of confusing, but the simplest terms is you have 3 levels of courts in Indiana in particular, and in most states. You have the trial court level. So that is the county level of the courts, essentially. So the vast majority of cases go in at the trial court level. That's that superior court, circuit court, probate court. There are some smaller courts, city courts, town courts, some separate small claims courts. Most of that, though, throughout the state is going to be wrapped up in the trial court level. And then you might have some separate parts. So most probate courts are actually subsets of a regular superior or circuit court. So when you're looking at stuff on a county level, you're going to primarily be looking in superior and circuit courts, and then their probate arms. But there may not be a specifically named probate court. You need to remember that when you're looking at estates and things like that, because it's usually wrapped up into the superior or circuit court. That's the way it is in Indiana. There's no specific probate court. The probate courts are part of the superior or the circuit court. and then they have a separate magistrate often that handles that stuff, which is essentially just another term for a type of judge. Next level up is going to be your Court of Appeals. That's where you have the best records that are kept, but they're not the most complete, simply because in order to get there, somebody had to have filed for an appeal just to get to that point. And for a lot of the stuff, you're going to be looking for a lot of estate stuff, a lot of family records, divorce proceedings, real property things. That stuff's just not going to be in the Court of Appeals unless it's extremely contentious. So those are the juicy ones that you find. So if you wanted some good reads, go look up the old cases for that sort of stuff in the Court of Appeals, because it's going to be the more fun facts. There is a tax court as well in Indiana that handles exactly what you'd think. It's issues with tax disputes. Next step up, the highest in the state, is going to be your Supreme Court. Most states call their highest court the Supreme Court. You know, kind of makes sense. The name says it all. And in Indiana, just like in the U.S. Supreme Court, they don't have to take a case. There's some limited circumstances where they do, because they bypass the Court of Appeals. That'd be stuff like death penalty and things like that. And then they handle all, you know, everything involving any attorneys, judges, things like that. But they can decide not to take a regular case. So if they think the Court of Appeals got it right, or if maybe they just don't care that much, they can deny taking the case. Now, this is Indiana, fairly streamlined. Well, let's take a look at kind of the opposite end of the spectrum when you're looking into courts. New York has weird names for their courts that most states don't. The first thing you'll notice at the very top, their Court of Appeals, unlike most states and even the federal court system, where the Court of Appeals is the first court that you would appeal to after a bad trial court decision, New York calls their highest court the Court of Appeals. So this can make for some confusion for some people, because here's what's going to happen. You have a Court of Appeals, but then if you look down a little bit, you've got a Supreme Court there. Well, guess what? The Supreme Court's a trial court. That's one thing to take when you see, anytime I see something out of the state of New York where they talk about the New York Supreme Court did something on the news, and it's always, you know, oh, the Supreme Court did something. Well, it's actually just a trial judge who made the decision. It's not actually the state of New York making a decision on something. So this is important, though, when you're looking at this. This is really, I don't need to go into all of it, but it is to illustrate that you need to know the court system for the state that you're in to know where you're even looking for stuff. So if you find out that something's in the Supreme Court, you're not going to find it in appellate stuff. You're going to still find that in a county by county sort of record, or district, or however the state is set up in a given state. Now, when we're talking about just legal terms that you find once you locate your documents in these separate courts, the most important resource that you have is Black's Law Dictionary. So what this is, written by Henry Campbell Black originally. This is late 1800s, early 1900s. And then there have been, I think we might be on the 13th edition now, could be even further by now. This is the, in some ways you can think of it as the black letter law of dictionaries. The terms used here are actually accurate enough that in most jurisdictions, they are cited as the legal definition of terms. Now, they're not binding on any particular court unless a court has specifically said, hey, from now on, this is the definition we're going to use. But anytime you're going to see any sort of legal arguments or terms that get used in cases or in documents that you find, first place to go if you don't understand it is Black's Law Dictionary. The editions, each new edition is quite expensive. So investing in a paper copy may not be the wisest. An older version is probably just perfect for your purposes. And in fact, A really old version may be ideal because the definition could have changed slightly over time. So if you find one, if you're looking for records from the early 1900s and you happen to find a first, second, third edition, well, hey, that's going to do you even better. Now, that said, let's go ahead and dig in a little bit to the terms. And these, as I want to stress again, these are just general terms that I'm going to be going over without being super specific on them. But to start, we have common law. And common law is not common across the country. Common law is something that's set state by state. This is law that is judge made. So if you think about it, this is the law that would have evolved over time versus law that's created by legislature. So in a system where, and we still have systems like this in France a lot more, and other countries, European countries, that have more of a common law that's constantly kind of evolving versus a statutory system that our states and our federal government have much more of now. Just even within the last 50 years, the common law is still there, but the statutory and regulatory law has just exploded. So in the time periods you guys are going to be looking at, you're going to be looking through stuff that's going to be based on common law. And a lot of things such as family law and divorce stuff and everything still uses a lot on that, on the common law. So what's a court of law? Well, nowadays a court of law is a court. However, it's called that now, but traditionally a court of law used to be one that dealt with law. And that was different from a court of equity, which you'll often see called a chancery court. So the court of law deals with things like damages, criminal matters, things like that. Whereas an equity court, the chancery court, they ordered specific actions to occur. So if you really think about it, something that's equitable, what is right, what is just to occur, that would be something where you have disputes over possession of property, things like that, where you're trying to get the court to do something, not just issue an order for damages or something like that. Damages being money payment. So those are the distinctions there. Almost every state has combined the chancery court and the court of law just into a single court of law now versus having them separated out. The name still is out there, and but for the most part, everything you're going to be looking at is going to be modern times. Those two terms are combined. Now, statutory law, I already kind of alluded to. That stuff that's actually written by the legislature. It is in specific terms, specific language, no paraphrasing there. This is what the specific law says. So you have the United States Code, you have Indiana, the Indiana statutes, Indiana Code, each state having their own, of course, but that's the stuff that when you're looking at something that's statutory is going to be something that the legislature has created. So any sort of appeal is going to be where you're requesting that a higher court review something. Now, that can be an appeal to a court of appeals. It could also be if you have something decided in probate and by a magistrate, you can ask such as, you know, in Indiana, you can ask a superior court judge to review what the magistrate did. Magistrate being kind of like a small step down from the traditional judge. The appeal usually is one of right, except if you're going to the highest court. So the term transfer, when you're looking at Indiana law, transfer is what you would file similar to certiorari when you're trying to get to the U.S. Supreme Court. Well, instead you file for transfer to the Indiana Supreme Court. That's asking them, hey, would you take a look at this case? Is the best way to phrase that. A writ is something where you're trying to get a specific order for a special purpose from the court. Most widely known as writ of habeas corpus, literally give up the body, where somebody's trying to get a judge to issue an order saying, hey, release this person. Okay. Writ of replevin is a common one you guys are going to see. The writ of replevin is essentially, hey, give me back my stuff. Okay. It's you're trying to get the sheriff to go, he's going to execute the writ and, you know, get your things back or transfer property. So if you see that one, I don't think replevin's on my list, but that's one that you'll probably run across. When you see an affidavit is essentially a statement under the penalties of perjury that what you're saying is true and it's based on your own knowledge. We use these today. Those have been used, you know, for years and years and years, long past. You're going to see affidavits, things, you know, you have anything from a paternity affidavit to affidavits by administrators for estates or guardians or things like that. It's literally just a way of a paper filing in court saying, this is true on my oath. All right. Chattel. Okay, so cattle are chattel, but not all chattel are cattle. Chattel just means personal property. So that's the difference is chattel property versus real property. Real property, of course, being land. Same way it's used now. Real property is actual land that you're dealing with, or improvements on the land, which would be things like houses. A recorder, I'm almost certain all of you are already familiar with. You have your county recorders. They're the ones who record deeds, liens, any sort of documentation about ownership, really, or somebody's interest in something somebody else owns. So, of course, you have liens that are placed on homes. You have the homes themselves are going to be recorded in the recorder's office. Property deeds, all of that stuff. It's all with the recorder. That's one of the most important things for you to familiarize yourself with when you're looking for records, any sort of legal records in the United States. The county recorders are the ones who kept that stuff. It's not going to be found in like state records for the most part. So that's the place you want to go looking. Now, a probate court is a court that handles guardianship, estate work, wills. Usually it's stuff that is kind of more of a specialty within the probate. So literally what one of the terms is, you probate a will. So one, you prove the will, you prove the contents, and you show that it's been executed. So the executor of the will has taken care of it. An attorney in fact is not an attorney. You don't have to have a Juris Doctor, or you don't have to be admitted to the bar to be an attorney. In fact, it literally just means, hey, I'm giving this person permission to act on my behalf, legal permission to act on my behalf. Most states now have statutory requirements as far as you have to list exactly what they have authorization to do. So you can have an attorney in fact for one or two things, or to do one particular thing, such as sell a piece of property. But it's just an authorization for somebody else to act on your behalf as though you were doing it. The term incompetent does not just mean somebody who doesn't know what the heck they're doing. It just means anybody who can't make a legal decision, which would include somebody under the age of 18, a minor. They're considered incompetent for doing anything that would be binding on them by law, or from making a decision that would be binding. So if you see that term, they're not saying somebody's stupid. They're just saying that this person doesn't have legal capability for capability to make legal decision. Now, a infant, likewise, is not an infant in common terms, not a tiny baby. An infant is just somebody who hasn't reached the age of majority, so they're not 18 yet. That's all. So you're not an adult, you're an infant. There's some bright line there. That's not always used. A lot of times you'll see minor or something like that, but infant kind of was more common back in the day, and it's still somewhat used today. Now, a lot of you have heard the term fiduciary. It's almost always said in terms of duty, fiduciary duty. You have a fiduciary duty. That just means that you have an obligation to not only do something for someone, but to look out for their particular interests. So somebody with a fiduciary duty towards somebody else is supposed to act to the absolute best interest of the person to whom they have a duty towards. A guardian is more general. So a fiduciary tends to go to like one particular thing, such as, accounting, finance stuff. That's where you usually hear it talked about. A guardian is a lot more general, though, where you're trying to look over the person themselves, typically. There's a difference, though. You'll see the term guardian ad litem, not the same thing as a guardian. The guardian ad litem is a more narrow focus. A lot of times, currently in my practice, when we have a minor who, in my situation, we do personal injury law. If I have a minor who was injured and we have a claim, but the parent's not participating, because oftentimes when the parent finds out they're not getting the money and the kid is, they suddenly stop responding to me. We then have to appoint a guardian ad litem who is appointed solely for the purpose of pursuing that personal injury claim. So they're appointed for one purpose. If you're appointed guardian ad litem, you aren't suddenly the parent of a child or of a disabled person or something like that. Marriage bond is something that has gone by the wayside, but used to be, if you were going to marry someone, you would actually, a man would go into the courthouse and post a bond, basically to, first of all, signify that he was going to marry the person, make it a little more serious, but also if, it turned out that he was already married or something where it was an improper marriage, the bond would be forfeited, something like that. So the suffix trix, you're going to see things like executrix. That is just the female version. So not really used a whole lot anymore, but very common in older records. So you have an executor of a will, or you have an executrix of a will, kind of thing. In re, you're going to see a lot, particularly when it comes to anything as far as property, family, guardianships, anything like that. It just means in the matter of or regarding. So, even with letters now, you have an RE colon, that's re, that's where that comes from, it's regard. The term cause, you're going to see used with like cause number, cause of action. That's a formal way of saying case. So if you see cause number, that's literally just telling you about the case number. If you see a cause of action, it's your case, why you have a case. So cause of action for negligence, sort of thing. The term caption goes to legal documents. It's the heading that goes on them. So anytime you have a case that's filed in court, you're going to see, I'll use Indiana for the example, because almost every state and federal does something similar to this. You have state of Indiana, county of, say, Allen, where I'm at. You would have the specific court, so the Superior Court of Allen County, and then you would also have the cause number. The nice thing about cause numbers, if you learn to read those in any given state, it provides you with a lot of information. So in Indiana, the first 2 digits of a cause number tell you the county. Then there's a letter that tells you what court, so if it's circuit or superior, or probate, things like that. The continuation, it'll tell you the date, it'll tell you the type of case with 2 letters indicating whether it's like a small claims, civil tort, something miscellaneous, things like that. And then the last part of it just tells you in what order it was filed. So it's going to have the number for that year. So if it's 56, it's the 56th lawsuit that had been filed or case that was filed in that court that year. So wealth of information, if you learn to read the string of numbers and letters that are on these legal documents, because it will actually tell you a lot about it. Now, I'm going to get a little bit into property terms. I'm going to preface this right now. property law is a headache today. It was a headache back in the day. So a lot of people, and usually those of us who have more than 2 brain cells, stay the heck away from property law because it's just confusing. I actually have a lot of respect for people who practice it because, quite frankly, I mean, power to them. There's going to be a lot of terms here that don't make a ton of sense. You just need to probably have a Black's Law Dictionary handy most of the time, because for even most attorneys, after a few years out of law school, we've put these out of our mind altogether. But some of the more common ones, fee simple is literally, it's the simplest form of property ownership. You own it. That's it. Nobody else has a right in it. Nobody else has anything. So a fee simple, you own it. A survivorship is when you have, say, 2 people who own property, and then a property right on a death will automatically pass to the co-owner of the property. So if you have a joint, the survivorship is the right that somebody has. To describe the situation between the two, you have joint tenancy, or really it's joint ownership of property, and then each of them has a survivorship interest in that property. So then you have a tenancy in common, where you have owners of property that don't have any sort of survivorship interest, so it wouldn't automatically pass to the other owners upon death. If you see something, and this is again terms used, so you're probably already familiar with this one, if you're partitioning land, that's when you're dividing one parcel of land into multiple, or like when the state divides Knox County from the early 1800s into numerous other counties, they're partitioning that. But in reality, when you're looking in the recorder's office, somebody's going to have a plat or a lot, and they're going to partition it out, subdivide it essentially. Now, tenancy by the entirety is extremely important for married couples everywhere. So only through marriage do you have tenancy by the entirety. And that's important because both spouses own the land, the entire part of it, at the exact same time. And the reason this is good is, so let's say one spouse has a huge debt. The creditor can't come in and take that spouse's half of the real property or force a sale of it, because technically, so if the husband owns the debt, the wife still owns the whole thing, just the same as the husband does, and so the creditor can't come after and take the property, which is why it's limited just to marriage circumstances, because otherwise you could have a bunch of people who play the system, try to use that to avoid creditors. But for spouses, it's a great thing. If you and your spouse don't have your property set up that way, I highly recommend that you do it. A life estate is exactly what it sounds like. You have the property as long as you're alive, and that's it. It's not automatically part of your estate when you die, like a fee simple would be. Okay, your ownership interest doesn't, it cuts off immediately upon death, which leads into the term remainder. So if somebody has a remainder, that means that they have a right in the property that will invest in them upon the death of the person with the life estate. All right. Now, a reversion is similar, but it doesn't require the death of somebody. So a reversion of property is when on a specific time or occurrence, the property interest goes to somebody else. So it could be that I own a piece of property for 5 years, and after 5 years, it reverts to whomever gave it to me. So let's say my parents gave me property for 5 years. At 5 years, it could revert back to their possession. Everybody who is in an HOA is familiar with the term covenant. It is, in the most simple terms, a restriction on property that runs with the land. And what that means is it doesn't go to the individuals, it goes to the actual property itself, which means if I sell my land, I cannot remove that covenant because it's already there. It's part of the land. It's part of what's being sold. This is good because it's a way for homeowners or other property owners who are nearby each other to make sure, kind of go in hand and say, well, hey, look, I'm not going to do anything that's going to impact your property, and for you not to do the same, let's all have an agreement that we're going to write into our ownership that you can't do X, Y, or Z here. So covenants can be a good thing, as much as people hate HOAs a lot of times, but they actually can be very beneficial. So now an easement, some of the more I mentioned, some cases not getting to the courts of appeal. Cases involving easements are much more common, and especially older cases. So an easement is literally when someone has a right to land, even though they don't have an ownership interest in the land. And what I mean by that is you have a right for some particular purpose. Most common is I own a piece of land that has no road access. Well, the law would give me an easement through someone else's property in order to get to road access, so it's not just completely blocked off. The utility companies have easements through all of our property. So those are kind of modern examples. What you'll definitely get into is when people file suits or get upset about easements that run through their property. So suddenly there's a driveway going through somebody's property or something like that. That's when you're going to start having those more contentious cases and have what I kind of call the fun facts about them. A restraint on alienation. Oh, and I guess that's not on my list here, but I'll talk about that real quick. So the most simplest terms, it's something that the law hates, a restraint on alienation. I guess it was on there. My apologies. So the restraint is literally saying, hey, even though I'm giving you or selling you or giving you an interest in this land, I'm still going to put restrictions on it. And courts don't like that. It's very, very limited circumstances where you can do that. And especially for like years beyond, the more restrictive or more onerous any sort of restraints that are put on any property, the court oftentimes will start striking those down because the ideal, what courts prefer, and frankly what anybody prefers, is that fee simple. You have ownership, complete ownership of your property. That's what is the cleanest, and that's the way the courts like to see things. Going through that, now we're going to talk about probate. Intestate. You have died without making your testament. So you haven't made a will. You died intestate with no will. There are specific, very specific statutes now that dictate how intestate succession, so how inheritance works through when somebody dies without a will. If you are married, no children, it can be, if you die without a will, not a huge issue. As soon as you start incorporating children, things like that, very quickly you're suddenly going to need a will. My big example for Indiana is if you die you have children, you're married, and you don't have a will, well, half of your estate will go to your wife, and then the other half gets split by the kids. And if you can imagine, that other half that gets split by the kids, if they're minors, gets put into basically into trust for them until they turn 18 and isn't able to be used by the wife. Well, suddenly your wife doesn't have access that property or to those finances or things like that. So it's very important. I tell everybody as soon as you get pregnant or your wife gets pregnant, go meet with somebody, make a will. That wasn't legal advice, by the way. So that's still what I tell you. All right. Letters of administration, something that you're going to run across. That is what the court gives to a administrator or an executor of an estate, so that they can basically go out and prove to people outside of court that, hey, I have authority to do what I'm doing. It's so that you need to get letters of administration so you can go access the bank account of a deceased person. Because you can't just walk in and say, hey, this guy's dead, I'm his son, give me his money. You have to actually get court approval for that. If you see the term advancement, this is not very common, but this is, if you think of the Bible, the prodigal son. He gets an advance. He says, hey, Dad, give me my inheritance now while I'm still alive. In order for an advancement to be valid, it has to specifically be, and in Indiana at least, has to be in writing that, hey, I am giving you this money out of what you would otherwise get when I pass away. And that's important because if there is a proven advancement, then the whatever that advance was gets deducted from the share of whomever that was given to originally. So what'll happen a lot of times is you end up with these disputes, and this is another one of the juicy fact stuff that gets into the appellate courts a little bit more, where we have one child saying that, well, that 50 grand was just that my dad gave me was just a gift, and of course you have other siblings who say, no, that was clearly an advancement on what you would have received when father passes. That term will come up. Like I say, it'll probably be more of the more interesting documents that you locate if there is an issue with advancement. So an heir, common term, that is somebody who is going to inherit, whether it be from intestate. In a will, it's usually kind of considered a beneficiary of a will. They're kind of the same thing, but an heir is the legally designated person or a legally designated person who is supposed to receive part of the estate. You have a bodily heir. Honestly, these terms aren't super common, but you might run across them. A bodily heir is somebody who's a direct descendant, so son, grandson, whatever. However, if you have a collateral, that's going to be somebody more like a cousin or even an aunt or something like that. Somebody who could still inherit, but not actually part of your line, so to speak, direct line. So we'll talk about failure of issue, but I guess I'll go over what the term issue means. Literally, your kid or descendant therefrom. So that's a direct line. So you've issued children. If you have a failure of issue, you don't have any kids. Okay, you haven't had issues, so you died without offspring. To escheat, that just means that nobody gets anything and the state collects. So that means if under the intestate statutes, there's absolutely nobody who could inherit. We're talking no cousins, no next of kin, no brothers, sisters, grandkids, parents, nobody out there. Well, it just goes to the state at that point, because realistically, there's nobody who should get it at that point. But it's rare that that happens, but it can. The will is the opposite. So you've heard last will and testament. It's a testamentary document, sort of like intestate. Well, this is your dying testate. You've given your testament. It is, of course, everybody's familiar. It's your directive on, hey, here's how I want my stuff to be split up when I die. A nuncupative is one that you're not going to see a whole lot, except for courts saying that it's invalid. That's the most common when this comes up. It's where somebody has said orally, this is what I want to happen. Well, what's fun about that, of course, is anybody can say, hey, my dad told me he wanted me to have this. Well, how are you going to prove that? You can't. So the courts say, nah, we're not going to allow that. We're really not going to allow that. So it's void in almost every jurisdiction. Offhand, I'm not sure of any jurisdiction where it's acceptable, but I also don't know everything. So a holographic will does not mean at all what modern holographic term means. It literally just means you wrote it yourself, and I mean literally with pen wrote out your will. That's a holographic will. Now, there is one situation where a oral bequeath can be considered valid. That's the causa mortis, extremely rare, but it's essentially where you have a deathbed gift. So somebody is, families gathered around, and person quite literally is about to die. And at that point, they can say, hey, I want you to have my, ring from my grandmother, something like that. So that's the only time when an oral bequeath is going to ever be, at least in the state of Indiana and almost, well, every state that I know of, will ever be valid, is when it's a deathbed. The executor, I already mentioned, executrix, that's just literally the people who are tasked either in the will itself or appointed by the court to make sure that the terms of the will are strictly followed. So they have, and incidentally, that would be a fiduciary duty to the estate to make sure that the will is followed, and also to the beneficiaries of the will. So it's a big responsibility, one that's taken very seriously by the courts. And if you fail in those, some very, very bad penalties can result. So, an ancillary is just essentially it's secondary on the will. It's you have your executor. Ancillaries are very rarely, you can kind of think of them as like a backup sort of thing. As far as any sort of executor goes, the term's not used a whole lot, but it is one that may come up. So letters testamentary, it's the equivalent of letters of administration. It's just for a will. So there's a lot of terms that are the same: letters of administration, testamentary letters, heirs, beneficiaries, things like that. Those are different terms, but they really mean the same thing when it comes down to comparing the two different types of probate. Now, construction. We're not talking about buildings or anything like that. You're literally trying to, at this point, construe the will. You're trying to construct what the will actually meant when the will just doesn't make sense. So sometimes if it's conflicting or unclear, then the court has to look at it and say, hey, can we figure this out? Can we get to a point where it looks like we really did, this is what was meant? What happens very often is that you can't reach a point where you have confidence, where the court has confidence that, well, this is what was meant. And if that happens, you can end up getting the will invalidated in its entirety, or at least that provision that doesn't make sense invalidated. So writing a clear will is extremely important, because otherwise it could end up just like you never had one at all. The codicil, you're going to see that's still a term used today. It's where you have a will written, and then a few years later you decide, I want to add something here. I want to give a specific designation so that, my grandchild gets this particular set of china. Well, you can actually slap that on as a codicil. Still has the same requirements to be valid as a regular will, but you don't have to rewrite the entire thing that way. It's just, staple up something else to the sheet of paper. Not quite that simple, but I already mentioned what beneficiaries are. That's something, essentially an heir under the will. There's two different types. So if you're literally just talking about money inheritance, or really any type of inheritance, but there's two types. You can do per capita or per stirpes. So per capita means all of the beneficiaries get an equal share. Per stirpes, much more common, is where people receive according to generational lines. So it's important because in one aspect, you could have two kids, a third child who's passed away, and then three grandkids from the child, or from your child that had passed. So two kids, three grandkids, each of which might get an equal share. Okay, or you end up in that same situation if it's per stirpes, where you would have a 1/3 to one child, 1/3 to the other child, and then the three grandkids would split the other third that your third child would have gotten had they survived. So when you're seeing those terms, what it's specifically saying is what percent is going to which people in which generations. A legacy is a gift of personal property. Money is considered personal property, and legacy typically talks about that. So if you find an old will and it talks about, a legacy of X number, it's literally just talking about, hey, I want to specifically give this person this amount of cash. A bequest is going to be personal property again, but usually a physical object, like the ring I mentioned, like china, silverware, things like that, where something's specifically earmarked, this goes to Mary, this goes to Peter. A devise, just another term, except it's for real property. You're turning over real property in your will to someone else. So every will has a residuary clause, a residual. And what that just means is, hey, there might be stuff in the time that I wrote my will to the time that I died, I'm going to have other things. I'm going to hopefully have more money. I'm going to have more property. And what it does is the residuary, you can say, hey, anything that's not accounted for in my will go to this person, or will just be distributed per stirpes, or something like that. So it's the catch-all, hey, in case I didn't account for something, let's have it handled this way. So after acquired property is exactly what you're worried about, and that's why you have a residual. It's where you obtain something after you've written your will, and that you never appended a codicil, an amendment, to account for it. So an abatement, if you are very wealthy when you write your will and you say, I want to give my son $1 million, and then you fall into poverty and you have $5, obviously your son can't get the $1 million, and maybe you had two sons, each supposed to get $1 million. Well, they instead get to split $5. Their legacy is abated at that point, simply because there's no money at that point. A lapse is when a beneficiary has died prior to the death of the person leaving the will. It's simple terms. So that means I wanted to leave my son something, but my son passes before I do. So his interest in that would lapse. You have terms, these are rare, but you'll see a term called a pretermitted child. And that's somebody who, when you didn't have knowledge of this kid when you wrote the will. So let's say your wife was, 2 months pregnant, a month pregnant, you didn't know it, you wrote your will, and you only included specifically your first two kids and not your third one. That would be a pretermitted child. There are special rules when it comes to that, and potentially, depending on how the will's written, you can still get that other child in and get part of the inheritance on it, even though they're not specifically accounted for. That's very much state by state, country by country, how all that's handled. So there's no like bright line thing that I can say, oh, here's how this works. Now, you have things, elections. So an election in probate is not an election in politics. An election in probate is when you elect to inherit based on intestate distribution rather than according to what's in the will. Most commonly, That occurs when a spouse decides to, usually without their spouse's knowledge, decides to disinherit their wife or their husband. And in that situation, the law does say, well, hang on, unless it's extremely clear that and there was some purpose for them being disinherited. So if a wife would receive nothing, she's able to elect to receive the share she would have received had there been no will. So it's kind of a protection there. So a spouse doesn't get blindsided and suddenly find out that they get nothing. A contest. This is not a friendly thing in the slightest. A contest is when beneficiaries, very often siblings, decide that they want to fight about terms in the will or the validity of a will. This is, again, one of the ones that will be more often one of the probate cases that you'll see in appellate stuff with, and usually anytime you can get into one of these, it'll give you a lot of good information, both about family, about assets, about property, all of which everybody's going to be arguing and fighting tooth and nail over to get some of that pie. So those are kind of very broad overview of some of these terms. You know, it's kind of hard. We can't really get into the meat on any of them through a program like this, but at this point, I believe we're going to do some questions here.